Good morning, dear friends and colleagues. It's my pleasure to welcome you today on the 25th of November 2024 at 10 o'clock in the morning. It's a Monday morning. A new week is ahead of us, and it's my pleasure to introduce Professor Dr. Miriam Buiten to you. Miriam is a professor at the University of St. Gallen in Switzerland, where she is also part of the so-called Law and Tech Lab. And we will certainly speak about that and what this is in a minute or so. I don't think that we ever met personally, but I met her online. That is important because we will talk about those instruments in a minute. I met her online because she announced there inter alia that she got her habilitation at the University of Mannheim just recently, and that she also received a prize for her habilitation, which is, and this is the moment when I was really interested in this, which is about platforms and platform liability and regulation of platforms, and in particular, the DSA. I then invited Miriam, and I then also had the opportunity to look a little bit more into what she's writing. And just to share this also with you, I would really like you to read, on the one hand, this article, which is published in the International Journal of Law and Information Technology 2020, which is about rethinking liability rules for online hosting platforms. And then this one here, this is one that is specifically dealing with issues of the Digital Services Act, from intermediary liability to platform regulation. This stems from a time when the DSA was not yet in force, so it's some kind of preparatory work. Miriam, thank you. So good to have you here. Was it a coincidence that we met on LinkedIn, or could we have met somewhere on Blue Sky, Twitter, whatsoever, or is LinkedIn the only one where you are of the platforms?
Thank you for having me so much. So, well, I would say LinkedIn is the one I'm most active at. Mm-hmm. I am also on Instagram, a passive user, but I do really try to limit my time on Instagram every day, and I don't post anything there. So I think LinkedIn is the only place where I post anything.
Okay, and why is this? Why is it LinkedIn and none of the others? And why do you use Instagram only passively?
Well, so LinkedIn, I think, is a great way to see what others are up to and really reach out to the rest of the research community. For example, you finding me there, I think it's a really great way to find new collaborations and learn about new research. I'd say the rest of social media, it can be really fun. It can be really great, but especially as a researcher of platforms and also all the downsides that go with it, I see also a lot of there are better ways to spend your time, let's put it that way. And also I feel I'm very cautious about sharing images and videos about myself or my family online.
But I mean, that's interesting because I'm also cautious when it comes to sharing very personal things, but I'm very active on most of the social media platforms, including in particular X/Twitter and now Blue Sky. And there are two reasons for this. The first one is probably I'm addicted, and I'm part of those who are really addicted to those services. But on the other hand, I also have an argument, which is I try to understand what's going on these platforms as I'm writing about it, and I'm writing and telling other people what they should or should not take into consideration. And I think in particular, Twitter/X is a very interesting example there for what's going on, because I think a lot of the things are changing there. And since Musk has taken over, this is very different from where it was before. And Musk is a very interesting case, and Twitter is a very interesting case because it also shows some of the limits, in my view, of the DSA, quite obviously on a daily basis, because using Twitter X has changed significantly since Musk has taken over. And during the US election, that became even more apparent, in my view. But you prefer having a little bit of distance to this and look more objectively into this, therefore?
Well, so I absolutely agree with you. There is also a big advantage in being on these platforms and seeing what's going on there. I have been on Twitter some years ago a little bit, but I never really could get into it. I felt that you need to put quite some effort also into really being a part of it. And yeah, it is a double-edged sword. There is an advantage of being there and seeing what's happening. But yeah, especially with X under Musk, I also have indeed my reservations of contributing to that. So, but yeah, I see your point as well.
Yeah. So perhaps after that, you could consider to go to Blue Sky then instead, because that would make Blue Sky certainly more attractive, because you are one of those who are really experts in the domain of platforms and platform liabilities. Where
Yeah,
does
I have looked into Blue Sky a lot. Yeah, maybe
yeah.
I should actually join.
Yeah, actually, it's very interesting. I've been there now I've been there for 8 months or so, but I try to be more active now since a week or 2 weeks now. And it's very interesting because one of the funny things I haven't understood yet is what the business model behind this is going to be. So I don't see it yet. I mean, I read now that they will go for some kind of subscription based services, and there's no advertisement visible yet there, so I don't know how they are. It would be interesting to know where all the money comes from, right?
Well,
that is,
it will
yeah,
be interesting to see if they can actually find a way to make money without the advertising model,
yeah,
because I would say that really a lot of the problems that we do identify on platforms stem from that very business model. So it will be
mm,
very exciting to see if another type of business model can work effectively and maybe with better outcomes for the type of information we see.
yeah. But interestingly, Musk has tried this too, right? So I mean, this was one of the changes that he did, but I think he failed quite dramatically. Nobody is really willing to, almost nobody is really willing to pay for X/Twitter. Perhaps it will be different with Blue Sky. Let's see. But Miriam, so where does your interest for platforms then come from? It's not so much your personal involvement into this; it's more from an abstract legal point of view. Then that makes them interesting.
No, I think maybe not so much an abstract legal point of view. What really interests me is that platforms have become such a pervasive part of our everyday lives. And so not only of us and our daily lives, but also of our society and the impact on the access we have to information, that I simply believe we should understand really well how platforms work, what the possible risks are, and how policy should respond to that. So for me, it is really about that this is an issue that affects almost all of us. Hardly anyone doesn't deal with a platform on a daily basis. And so that is where my interest stems from. And actually, I started working on this, working on competition law and on market power. And that is how I got sort of into this topic. And then it became clear quite quickly that market power is one of the issues, but maybe in a way the least of our problems. That's not totally true, of course, but so many problems and issues come together when it comes to platforms. We all really enjoy their services and they make our life a lot easier in many ways. But at the same time, we really have to be aware, I think, also about what impact it has on how we access information, how we communicate, and how that even affects our elections and other big, important topics.
Yeah. First question there now obviously would be whether you think that platforms are something which are there to stay. So we have seen them now for more than 20 years, most likely. But one could also argue that platforms, it's very much up to how you define the peculiarities of platforms in order to say whether this is a specific legal issue per se or a subject to study. And others might argue that things are already changing now once again, that we see less and less platforms, or we see more and more of curated content that is not typically affiliated to social media platforms as we know them. So do you think that this is a transitory phenomenon that's going to disappear, or will we talk about platforms in 10 or 20 years still?
Well, what we will call them then is one thing, right?
Yeah.
I would rather think it's part of a bigger phenomenon where we see big technological changes that also go together with maybe economic changes or new business models. And it takes us all a while to figure out what is really new or different about that. We use the opportunity, we make use of it. It leads to great changes. And then it takes a while for all of us to see, should we also be worried about this in some way? And so I think it's part of a bigger aspect of how does technology impact society? And how should then lawmakers respond to this? And that for me is with platforms, a lot of that comes together there. They use a lot of algorithms, and now AI is going to be integrated into them a lot more. They rely on this, back then sort of new concept, or they make a lot of use of new technologies in combination with these two-sided business models where they serve different groups. And so a lot came together where it was very difficult for all of us to really understand what is a platform, what does it really do? And platforms have really seized that opportunity to, for a very long time, sort of present themselves as We don't do much at all. We are just a technology company. We allow you the opportunity to exchange and to interact according to your wishes. And all we do is fulfill the preferences of our users. And that, I think, that's also what interests me. And that's, I think, what's going to continue to interest us as researchers, as to how should we really understand what these companies are doing, these companies that call themselves technology companies, but that influence our society and our daily lives so much.
Yeah, Miriam, that's an excellent point, because that brings us now already into the content of all your work. I mean, the phenomenon started somewhere in the 90s, and some of the decisions taken, in particular in Europe, in the e-commerce directive stem from the 90s. And some of them are based on the argument that platforms are nothing but objective, neutral places where people can meet and do whatever they want to do, and the platform is out of the game. Obviously, that has been one of the founding reasons why platforms have become so successful. And obviously, some things have changed here since 1995 or so. Could you please indicate how you assess the development, and then in the second stage, how you assess the development of the European legal answers to these developments?
Absolutely. Yeah, so in the 90s, the idea was really that platforms, they provide a space. They provide the technology, and the technology was often considered something objective, something uninvolved, where users can exchange, they can communicate. And the platform really didn't do much more than give users that digital space. And over time, it became clear, actually quite quickly, that platforms couldn't really operate in a fully uninvolved way. They had to really quickly already start making decisions about what kind of content would be allowed on their platforms and what wouldn't be. And for a very long time, platforms really completely downplayed that role. And they kept always saying, we want to be objective and neutral. We don't want to be involved in this. We don't want to decide if this is something that's just over the line, that's not allowed, if nudity should be allowed. We just want to stay out of it. And it's only been in the last 5 to 10 years that platforms have become much more open about the fact that, yes, of course, they make a lot of decisions about content, and they are not just technology companies. In the end, who work for social media platforms, it's a lot of moderators that decide or that look at content and see what is allowed and what is not allowed. And the fact is that the legal regime has had a rough time catching up on this. And so in the 90s, indeed, the rules that were adopted, a very central pillar of that was this liability exemption, or also called the safe harbors. And these safe harbors, they were meant to make sure that platforms weren't put in the position where they would have to moderate all content and oversee everything that happened, where they could be made responsible for what a user would say or would post on their platform. And there was, of course, a good justification for this, that a platform could not operate as a viable business model if they would be made responsible for this. But over time, platforms have been continuing to rely on these exemptions, and in the US they're much more far-reaching still than in Europe. And even now, with the new Digital Services Act, we have all these regulatory obligations for platforms. They need to be more responsible. But this old idea of that a platform should have these liability privileges, that they should not be responsible for what users post, that continues to rely on this idea that a platform is just a neutral, mere technical provider of space where others can post content. And that is simply not the case anymore. And that is one of the main propositions of my research, is that we should really look at what a platform is and does, both for these obligations, as the DSA now does, but also when it comes to their liability, just overall for their responsibility. We need to really look at, what does a platform do all day? Well, they make decisions about content. And in many ways, this has a lot of similarities to what, for example, an editor on a media company would do.
Mm-hmm. So let me just clarify, if I may, a little bit. The statement that you're making at the moment is a suggestion to change the DSA, therefore?
Yeah, so what I propose in my book on platform liability is that these liability exemptions are no longer appropriate today, and that in a way they also don't really apply anymore, because in many ways they have been advanced to increase the duties of platforms. So we have already this sort of duty of care approach in copyright law. We already have this approach where they have to make sure that notified content cannot reappear in other fields. But the notion behind it, and still in the DSA, that says a hosting provider provides space for others to post content, that is just a wrong starting point, because that is not what, for example, a social media company does. A social media company, their whole reason for existing is that they select content, they promote it, they recommend it. They are the ones deciding what kind of feed you see. And especially on a platform like TikTok, where people are really encouraged to passively consume a feed that's been pre-selected by algorithms, that's not about the platform providing this technical space. It's about the platform making decisions about what content reaches users.
Mm-hmm. Well, let's dig a little bit deeper, perhaps, if I may ask some questions here, and then perhaps also in a later stage, let's talk about the DSA and about how this looks in DSA. But let's start first from a very basic point of view, which is what we are doing at the moment, right? So the two of us, never having met each other, we are talking with each other there, and hopefully some people will see this. But at the moment we are doing this, nobody on YouTube knows what we are talking about or what we would be talking about. And probably it's just you and me choosing on what we are talking about here at the moment. YouTube doesn't have anything to say about that. And there are millions of people doing this every day on YouTube. And there are huge amounts of data coming out of that every day on every single platform. And it's true that the situation is much more rigid when it comes to copyright, but there's a huge difference here, which is that when it comes to copyright owners cooperate with the platforms. Both have the same interest, which is not having illegal content on the platform. Whereas if we started to talk about illegal things here, there would be a difference in interest, right? It would be us being interested in doing this and YouTube probably trying to chase us. So what is wrong on the concept that YouTube is just allowing us to talk here and to stream and to distribute this, which is fundamentally different from what we needed to do if we wanted to publish this interview in a journal somewhere? So is it really true that changed?
Well, so absolutely. Of course, there are differences, right, with the process, for example, of a publisher. I mean, we should not forget that the journalistic the codes of ethics and what journalists need to do before they publish something. Those are rules imposed also on the media, right? We expect them to pre-check everything. And of course, we don't want to expect platforms to do that because they couldn't operate. If anything had to be pre-approved that goes on YouTube, that would not be a viable system, and we don't want that. And also there are many, of course, freedom of speech, freedom of expression considerations for why we wouldn't want that type of approach. All that I am saying is that the notion that YouTube just allows us to post whatever we want, right, and gives us that space, that's not the full story, right? Because what YouTube, of course, YouTube could remove a video once informed about it being illegal, right? And that's also the approach that's central now. But platforms like YouTube and also Meta or Meta's platforms, TikTok and so on, they've also been known to algorithmically amplify a lot of controversial and problematic content, right? And some of that is not necessarily illegal. Some of that is just harmful, for example, disinformation, but also a lot of bullying or content that harms teenagers, for example, on TikTok, that promotes self-harm, for example. And here we could say, well, all the platform has to do is sort of respond to notices. But in fact, if we think of the platform not just as a space for others to post content, but as an entity that also moderates this content, that decides what videos are being pushed forward that end up in people's feeds, then maybe this should also carry a responsibility, possibly also in liability, for the choices they make there. So, for example, to take X and Musk, if Musk says publicly in the media all the time that anything goes on X, you can say anything now, then you shouldn't be surprised that people are going to also say and share a lot of illegal or problematic content, right? And then it is very odd. Any company that would do that is not a platform, would then carry some sort of responsibility, also in tort law, for the culture they promote in their companies and the activities that they are a part of. Only with platforms we say, no, they can stay passive because they are mere technical neutral entities and they should only respond to notices, right? To put it in, of course, a bit of a simplified way now. And that is my point, is that yes, they, of course, do not pre-check every content that is posted, but they do make a lot of decisions when it comes to their design, their interfaces, their algorithms, and also the governance of their platforms that influence very much what type of content is ultimately seen by users. And they should carry some responsibility for those choices. And of course, the DSA does that through regulatory obligations. But from my point of view, liability should play a role there as well, just as it does for any company.
Well, okay, I think I get the point, but I have still several questions on this. The first one is you said it now, I think twice, that you're talking about illegal or problematic content. And I think this is a rather important distinction to draw, because there's plenty of content that is probably problematic or unwanted or not appropriate, or however you call it, but it's not illegal. And my question therefore would be whether you think that there should also be some liability for unwanted content or inappropriate content on those platforms, which is perfectly legal. And second question coming up to this is, my reading of the DSA is that unfortunately the DSA is not really very clear in drawing that line. And I think this is one of the reasons why some people are quite critical about the DSA from a fundamental rights, freedom of speech, etc. point of view. And I would really appreciate your view on this. And the second question on this, I think Musk/X is interesting, not only because he's constantly arguing that there is some freedom of speech on the platform, but it's also interesting because he clearly changed, or at least I read it as if he changed the algorithms and as if he was promoting his personal point of view, how the world should look like, very actively on his own platform and trying to have direct impact on, for example, the US elections without anyone hindering him on the platform. So this is more than just, drawing or not drawing a line here and establishing a culture of how should people interact here. And I'm also asking myself whether you think that should be limited in some way.
So absolutely. So these are all very valid and interesting points. So maybe just to wrap up sort of this liability aspect, right? So I mean, when we talk about liability, we're often sort of thinking maybe of this sort of strict liability that a publisher might have for the content that they publish, right? And that's not what I'm talking about. I am talking about some reasonable duty of care that just like any company has for the products that they sell, for example, that a platform also has a reasonable duty of care for how they operate their algorithms. And that then affects not only illegal content, but also harmful content. But that does not mean that you should or could make a platform liable just for allowing any harmful content to be posted. To me, there's a big difference between, does a piece of harmful content, let's say self-harm videos on TikTok, slip through? Of course, that happens. The platform cannot do that perfectly. It's the users ultimately that post that content. But if studies show over and over again that if you are a teenager on TikTok, that within a couple of minutes you will get self-harm videos promoted to you, then to me, that is something that TikTok carries some responsibility for, because they are the ones who are designing and maintaining their algorithms and pushing that kind of content. And this is my point from the beginning, is that the business model underlying this, that is really one of the biggest issues here, because the platforms ultimately care about clicks and about advertising, and their algorithms should also have some ethical component in there. And of course they do also to some extent, but that should be a priority to make sure that that kind of content doesn't end up with teenagers. I mean, so many studies by now have shown how harmful social media is to teenagers, that platforms carry a responsibility there. And of course, that is something that the DSA aims to tackle. And I do think it's a very useful approach that the DSA says for illegal content, we really have these very concrete obligations to remove the content. And we don't have that for harmful but legal content. Because of course, if they would have done anything else, then it's a very slippery slope to censorship and allowing also not well-willing governments to take a run with that and say, look, platform, you should be taking down this content because it is harmful in some way. So it is also a very difficult position for the policymaker to be in. How do you make platforms act against harmful content when we cannot really very well define what that may be? And so this it is true that is also criticized, and I think ultimately a lot here will come down to the implementation of these obligations. And so this is something that I try to do, for example. So I'm part of a Brussels think tank, the Center on Regulation in Europe, and there we're doing a project on the implementation of the DSA for child protection. And we're looking into, some of the design and systemic risk obligations for platforms to protect minors. And here a lot will come down to how that is actually interpreted. So how much should a platform really change its design to protect minors? What does that then really mean to address these systemic risks? And I think here it is really in the details that for the DSA to really make an impact here, we really need to have quite a tough interpretation of these obligations, that platforms really need to make changes to their recommender systems and changes to their governance structures. And so that brings me then to your point on Musk and freedom of speech. So this debate has for a long time on platform responsibility been very dominated by freedom of expression issues. And of course, rightfully so to some extent, because we want to be able to say things on the internet without being censored. At the same time, we should realize that platforms make decisions about what we post every day. And this is not because of the DSA or because of liability rules, but simply because, for example, Facebook prohibited nudity simply because they didn't like it. And so that has nothing to do with public oversight, but simply about the platform's own interest. And this is, I think, precisely what Musk is showing really well now, is that we should not think of platforms as this oasis of freedom of expression in any case. We are completely dependent on their owners and what they like, what they think is a good idea. And Musk likes to talk a lot about free speech, but his version of free speech has a lot to do with the things he likes to hear, or his views and opinions. And that's not, I think, what we all have as a common understanding of what the freedom of expression means. I mean, he's been known also to remove posts that are critical of him. Mm-hmm. And so it really precisely shows the point of that we shouldn't think of platforms as these spaces where we are allowed to say anything, and we should be careful that public policymakers don't come in and tell them what to remove, because platforms decide already what to remove, and they do so according to their private interests. And that's, I think, something that's very good about the DSA, is to try to get some public interests and public oversight into this decision-making process of platforms.
Mm-hmm. That's very interesting. If you agree, I would love to hear from you what you therefore then say about the exact wording of the DSA on these matters, in particular Article 34 and 35 of the DSA, which are probably the core of the issue here. So just to remind everyone, the liability exemptions are at the very beginning, and they have not changed very much since the e-commerce directive. And then there are specific obligations now for very large online platforms. Most of the social media, or all of the social media platforms we have been talking about so far, are very large online platforms. Although this is still disputed, this is also one of the funny things, that even that very fundamental question, what exactly is a very large online platform, can be challenged from a legal perspective. However, there's this rule in Article 34, which is about risk assessment, and then there is a rather lengthy article about the mitigation of risks after the risk assessment having taken place. And when you look into Article 34, and please, Miriam, comment on what I'm saying in a minute, when you look into Article 34, in particular here in this list here of what's going on, I see already a little bit of not so clear differences made here. So on the one hand, they need to have a risk assessment about the dissemination of illegal content through their services, fair enough. But then it's getting already it's getting much more blurry here, saying that any actual or foreseeable negative effect for the exercise of fundamental rights, in particular the fundamental right to human dignity enshrined in Article 1 of the Charter, blah, blah, etc. So in my view, this is one of the key issues here, because it's getting very, very difficult here to learn what exactly is meant by letter B here when we come to unwanted content such as self-harm, etc., that you mentioned. It goes on then with any actual or foreseeable negative effects on civic discourse, which is obviously a lot of things happening when it comes to political debates. Not everyone on Twitter/X, YouTube, etc., has very nice political purposes. And then everything which goes about gender, public health, minors, etc., etc. So in my view, this is my first question. I'm very happy to hear your comment on this. This is getting very, very blurry if you look into this in the detail. And then second, when it comes to the mitigation of risk measures as they look like in Article 35, this is a lot large companies do not really have a problem with, because pretending to change something and write a lot of text about, for example, that they tested and adapted their algorithmic systems, including their recommender systems, just to mention one of those points mentioned here, is very simple. And I'm very doubtful whether this is the right instrument to change anything here in the core. So question to you, Miriam, would you share my criticism, or is your view on the DSA more positive here?
Well, so I share your concerns that I also am a little bit afraid that it might end up being a bit of a paper tiger if there was going to be a lot of writing about, indeed, we did this and we did that, and we had limitations here technically, so we couldn't do this, and so we did that. And so my worry is that we're not going to actually see a lot of real change into how social media works and how it is being used. But I am optimistic that a lot will depend here on enforcement, on implementation and enforcement. So the question is, how much can one still get out of this rather vague language in terms of concrete obligations? I see that maybe there was a wish not to have these kind of concrete obligations with respect to harmful content, which, as these articles also show, is very difficult to define. And so I think that's also why there is this reference to the fundamental rights and civic discourse, to try and sort of define what that could mean. But I do see, I foresee the problem that we might get some guidance on specific topics, and it might not necessarily be very strong obligations to really change something. So as long as we have platforms that have as their business model to keep us engaged for as long as possible and show us advertising, I, for example, am quite doubtful that there is going to be a real change to how teenagers use social media. But perhaps the Commission will be very, very proactive. I mean, they have been so far with their investigations into forcing platforms to make changes there. And perhaps that will then lead to better outcomes for how the youth uses social media. Personally, I think social media should be prohibited for teenagers, perhaps even until an age of 18 or so. We also don't allow them to gamble, for example, and nobody doubts that. But so I think maybe we would in some areas need more far-reaching obligations, and maybe in other areas we don't necessarily need to get all these reports on everything, because is it really going to make real change? So I agree with you, but I am optimistic that we could still get something out of this with implementation and enforcement.
Okay, may I use your law and economy background for a second now? And if we agree on that, there is a lot of uncertainty in the text, and that we hope that the Commission is going to provide some more clarity here in the future. Even if the Commission tried to provide some more clarity here, it will take another, 3, 4, 5 years until this is finally decided by the Court of Justice of the European Union. So we have a situation of very clear uncertainty, legal uncertainty at the moment. And the question to the economist now is, uncertainty is always good for players that are already on the market, and it's very difficult for players trying to enter the market. So this is very harmful, one could argue, for startups, European startups in the platform business, because different from Meta, Musk, or whoever you call here, that have unlimited resources to fight that out in front of a court. And Musk probably doesn't really care at all, because the whole thing is just a hobby for him. At least it looks to me like this. So this is something which could perhaps even do harm to the European to startups such as Blue Sky, if that, or similar European initiatives. And second question, I find it very interesting that you say that children up to 18 should not have access to social media, and that you compare this with smoking. Two questions coming out of this. Would you argue that this is, from a fundamental point of view, a fundamental rights point of view of the children, legal? And second question, how should that be enforced? Because it would require some kind of working age verification system, which isn't there yet, although people started to think about that somewhere in the 80s of the 20th century already. So how could that ever be achieved in a legal way? And is this realistic? So two very tough questions. I'm very sorry.
No, that's absolutely fine. So to start with your second question, well, so I mean, I am aware of that, right? So this is also a bit of rhetoric as to the type of things we might need to think about, that we really need to perhaps think in a more extreme way. Age verification is also a topic that we're thinking about, and how that could be done. Because I mean, already now there are rules also in various member states on that platforms have to comply with when it comes to age verification, no matter how difficult it may be.
Yeah, sorry, may I just jump in here? Yes, but completely useless when you look into how age verification does not work for content that is obviously not appropriate for children, such as porn, in Europe. Absolutely no change in the last 30 years in this, right? At least nothing that I know about. And it was so the children are already now affected by the porn their parents should not have seen on the internet, and there is absolutely no change here, right? Although we have been talking about this now for 30 years. Isn't that
so
really
I
unbelievable?
agree. So this is a very difficult topic, and perhaps this is not something to tackle with like legal prohibitions. I mean, I've been reading also about, for example, psychologists who say this is much rather also something with education and common approaches. You know, like no mobile phones in schools and things like that. I mean, I think it should be part of a much broader movement where we are worried about what this is all doing to our children, right? And that's not limited to social media, but just the use of screens by children.
Yeah.
And what it does to their development and the unhappiness among teenagers, but also their inability to stay concentrated or make real social connections. So I agree, right, that legally there are a lot of difficulties here. So maybe this is me also less speaking as a lawyer and more as a mother potentially, right, of what we need to do here. I think here it is also just we need to all get some awareness of what this is doing, and I feel like that's also lacking, and people are all just like, yeah, my child does it, all their friends do it, there's nothing we can do. But we need some collective action. So the law and economics approach, I mean, that it's just very difficult to get that kind of collective action to really do something about this. And I agree that perhaps we won't get it with sort of a legal approach. I make the comparison to, for example, gambling, because it's also the mindset that we have towards it. And so to your other question, right? So of course there is a fundamental rights issue of also the access of teenagers to information, and they should have access to information. So it's much rather about how can we make this something that will work for them. Because I have the feeling that on balance, for many, many young people, it's something that's not doing them good, or at least it's doing them on balance not so good.
Yeah.
So yeah, it's a very complex issue to tackle, and I do think that the DSA is making a difference there. So now on your other question, on the large and the small platforms. So of course, this is the reason why many of these systemic risk and other obligations are targeted only at the very large online platforms. And so it will be important to get very clear on what a very large online platform is, exactly to provide smaller players with the opportunity to grow.
May I jump in once again? I'm sorry, Miriam.
Of course, no, yeah.
Blue Sky has a growth rate of 1 million users per day today, if the figures I read are correct, right? So even if they started from zero, it would take them 6 weeks, and they were suddenly potentially a very large online platform. So
yeah, perhaps we need to. No, that's absolutely true. I mean, perhaps we need to actually make some differences here also between the business model of platforms and their monetization ways, and maybe if you don't use advertising, that you have some leeway there. But no, that's absolutely true. Of course, what would be the alternative, right, for regulatory approach like this. I think it's also sometimes easy to say, well, this might not work, but what would be the alternative? I mean, at some point, if a platform is that large and does pose these risks, then we may need these types of obligations. Now, at the same time, we also have the Digital Markets Act that tries to at least constrain the biggest platforms in abusing their market power, and also giving the opportunity to smaller platforms to have a chance. So yes, I agree with you that it's costly for platforms. And in Switzerland, we're now awaiting a proposal for platform regulation. And I could imagine that they're going to take a leaner approach with fewer of the sort of reporting and transparency obligations and focusing more on the users, right? So yes to these notice and takedown conditions, but no to many of those reporting obligations, and that might then be a bit easier to deal with for the largest platforms. But for the newcomer, fast-growing platforms. But yeah, so I agree with you here, but I also don't see a very good alternative. Perhaps the DMA approach of also having this for at least 3 years and things like that could have been a way to go. But we also see that much of the harmful and illegal content shifts very quickly to other platforms when public regulators come to crash down on big platforms. Or now that Telegram, for example, is cooperating with police, illegal content or illegal activity tends to shift to other platforms. So at the same time, we also cannot say, oh, well, we'll limit these obligations to the biggest platforms, because then if other ones are as big and they're not subjected to these obligations, where to draw the line then? I think that's the issue here. Yeah.
Yeah, if I may, I would like to open just another very big box, but probably that will be the last one, if you agree. That will be the box of our own role, being legal academics in the domain, right? So what I find really interesting, what you are doing, if I understand it correctly, what you're doing is that you are really criticizing the existing legal framework, and that you are suggesting how to change the existing legal framework, which goes beyond just describing what the law is saying. And I have two questions coming out of this. The first one is, in how far are we limited in doing this, or is it part of our profession to do this? So are we different from anybody else asking questions and providing solutions in this debate? That would be the first question. And the second one would be, how would you suggest the process of discussing the DSA and reforming the DSA would look like when it comes to academic input into this? So is the system how this is done at the moment, which is that the Commission asks for whoever wants to provide advice whenever there is a project coming? Is this a very appropriate approach? And final question, what would be your perspective on how this is going to go on now? So, I mean, one of the things we've seen with GDPR in particular, which is quite similar in some ways in like the DSA, is that it takes 10 years, 20 years until a reform of this is really realistic. Would you see this also as a scenario here, so that the DSA is put into this and is set in stone now for the next 10 to 20 years, or are you more optimistic that this is going to change?
And so I think your first and last question I may actually want to combine. So I do completely see it as our role as legal academics and researchers to play a role in making the law and creating the law. So of course, a big part of it is also understanding, interpreting, and building on, let's say, the building of laws that we have. But I really also see it as part, and especially when it comes to new technologies, new business models, to sort of think, what if we didn't have any rules now? Or what if we were rethinking this from scratch now? Then what would it look like? And that is, for example, what I've aimed to do with this, with also my book on platform liability. It's just to say, if we wouldn't have anything right now, then what would we be drafting in terms of rules? And sometimes path dependency can really guide rules for a very long time and not necessarily be the best or the appropriate solution. So this is also a broader view that I have of how we regulate new technologies and how we regulate new problems, that we have to try and find how do they fit with the principles that underlie our whole legal system, not necessarily maybe the specific rules that might have been governing that, and come up also maybe with a theoretical framework or a way of thinking of how should we best deal with this problem. And I do think that it's not always the best thing to then come up with yet another technology specific set of rules. I do see that at the moment right now, it's been useful to think of platform regulation and have these regulatory obligations for platforms. But ultimately, the goal should be to incorporate in sort of an existing legal body everything, all these new problems that are coming up, because platforms they might have started as sort of a niche business model, but they become part of so many businesses and so much of economic activity that it's becoming maybe more the norm in many ways than the exception. In any case, when we think of digital companies also. So this is also a bit when we think of AI regulation, platform regulation, data acts, data protection. So we have so many initiatives there to try to sort of put a patch on a different problem. My approach is we should really think of trying to think in a coherent and holistic way of how to approach these problems. And that's, of course, easier said than done. So that, to your last question, then, I do think that it will take a while before we would have a reform of this. But I think we should be ultimately thinking much more about how to streamline this into maybe not have these very specific concrete obligations for platforms, but get to a place where we have more responsibility of platforms. So maybe in a while we will be able to achieve that in different ways, and have, for example, for video sharing platforms, the closer they get to other video media sharing platforms, more rules for them or more rules in another area. So as to your second question, you have to remind me real quick.
That was about whether the way the Commission organizes input at the moment is fit for purpose.
Yeah, I do think it's great that everyone has the opportunity to share their views during the consultation. I really rely on this a lot. Also, reading what others have said, I do think it's a way to get giving everyone a chance to contribute, right? Because in many other settings, when there are, for example, workshops organized or experts that write reports, there is much less opportunity for the many to right. You have to get a seat at the table to share your views. So I think both are important. My impression is that with the DSA and the DMA, there has been a lot of exchange and dialogue between various parties, maybe more than in other settings from what I've seen. I think this has been really great, that academics have given a lot of input, social society, civil society has given a lot of input. So I think we do need structured ways to have real dialogue, and already early in the process. I think sometimes it comes maybe a little late in the process. There's already a proposal and then you can comment on that, but you cannot really think about the fundamental ways of approaching the policy topics. So I think that would be a great way to still expand input from academia and civil society. But I do think we have many opportunities to exchange. And we should also as academics, of course, organize these type of things ourselves and organize conferences and workshops where we don't only talk among each other, but also with other stakeholders in these policies and processes.
Yeah, absolutely. There's plenty of work to be done in this, and I'm quite sure that the DSA will be a lot to talk about for the next years or so. Miriam, thank you so much for your time. I will close in a minute, but not before having asked you whether there's any input that you still want to provide that I hadn't asked you about.
I've talked so much already. I think I think I've said enough. So yeah, maybe the one thing that we really research this topic and we think about it a lot, but I see it almost. I find myself at dinner parties also talking to others about that they should really watch the type of content they post, or and the time, or how they use time spent on social media and so on. I do think it's a topic that should actually interest all of us. I guess many researchers will say that, but I really do think it's true. That all of us should be thinking about what do we want from these companies? How can they really improve our lives? And they do in many ways. But how can we make sure that we don't, right? As I've said earlier, not today, but in another occasion, we should be determining how they work for us and not the other way around.
Absolutely. So if someone wants some more food for thought in this, please consider reading the articles of Miriam Buiten. I screen them once again here. about the DSA. And there's a book coming out in the very near future. Miriam, when is the book going to be published?
Hopefully next year, but it might take a little bit longer. I'll keep you posted on LinkedIn about
Absolutely. And I will read it, and then I will invite you again, if I may, after having read the book too, and not just the articles. Thank you so much for your time, Miriam. Thank you for your time that you listened to this. I appreciated it a lot. I hope that we stay in contact. I hope that you stay interested. And in particular, I hope that all of us stay healthy or become healthy as quickly as possible. Take care. All the best. Bye-bye.
Bye-bye.